let's talk about second DUI in the state of Indiana. In Indiana, there are two types of second DUI arrests. Now, the first one is if your second DUI is within 7 years of your first one. We're talking conviction to arrest date. That is going to be charged as a level 6 felony, maximum time in jail 2.5 years, maximum fine $10,000. Now, the second type of DUI arrest for a second time DUI is if the previous DUI is outside of 7 years. So 8, 9, 10, 11, 12, 13, 15, 20, 25, 30. Earliest I've seen is a DUI from 1977 used to enhance a new DUI. So sometimes people say, well, Mark, my other DUI is outside 7 years, doesn't count. Or sometimes people say, Mark, my other DUI was more than 10 years ago, it doesn't count. They count. They absolutely count. So again, I have dealt with a second DUI offense where somebody got arrested in 1977 for a DUI, and they get arrested now because spouse passed away, some terrible tragedy, or they just had a bad day. And they're still used that as an enhancer. Now, sometimes BMV records get lost, and we're not going to be raising our hand, hey, we have a second DUI. But it counts. It doesn't matter how long ago, doesn't matter whatever. It counts. 15, 20, 30, whatever, they count. So keep that in mind. Now, as you might guess, the law looks at a second DUI within 7 years of your first one a little bit more serious than a second DUI where the first one was more than 7 years ago. But there are some things in common. Number one, a driver's license suspension, the minimum is 1 year. That's just in the statute. So there's going to be a minimum 1 year license suspension. So we have to have a mechanism for getting a person to drive. So typically SDP, prosecutors are a little bit easier to get someone to agree with that if the second DUI is outside of 7 years. But that is a fact. Now, the second DUI, if a person's convicted, they have to do one of two things. First one is 5 days in jail or 240 hours of community service work. Now, sometimes clients hear, well, I get to choose. There's a bunch of different problems with that. Number one, those are the minimums, meaning the floor. Prosecutors typically want much more than the minimum for a second time DUI offense because in their mind, a person's not getting it. They're making the same mistake. Again, they've already had a chance to correct their behavior. Most prosecutors want much more than the minimum of 5 days in jail or 240 hours of community service work. Now, sometimes clients think, well, I'll just choose one or the other. I'll take the 240. It's not that simple. Sometimes prosecutors won't offer the community service work. And then even if prosecutors do offer the community service work, there are a number of judges in Indiana, in the counties that I practice in, that won't accept it. No, if you get a second DUI, you have to go to jail. I want you to understand how serious this is. And they just won't accept 240 hours of community service work. Some judges do, some don't, and it's not up to the person that's been charged. Again, these are the minimum floors to receive federal highway funding, so it's not necessarily up to the person who got charged with it. Now, extenuating circumstances sometimes will help push a prosecutor or convince a judge to offer the 240 hours community service. Severe illness, elderly, infirm, other problems of that magnitude, but typically it's inconvenient, or I don't want to, isn't going to be able to persuade the judge that will not offer it. So it is a challenge sometimes because nobody wants to go to jail. I get that. And especially in a county where they don't offer the community service work. So we are often fighting second time DUIs pretty extensively. We fight all DUI extensively, but for second DUI, we're trying to fight these because we understand nobody wants to go to jail. And 240 hours of community service work, that's a lot. That's a lot of community service work, especially if someone's working full-time, taking care of their family. So we understand that second DUI, it's not fun in any capacity. Now, typically, judges and prosecutors will be a little bit easier to convince if prior DUI is long time ago, as opposed to more recently. But I just want to talk to anybody here. If you're thinking to yourself, oh, my second DUI is a long time ago, I don't got to worry. It is serious. And many judges and prosecutors take that second DUI. Like I said, someone's not learning their lesson. And so it's super important that when a person is arrested for a second DUI, whether it was 1 year ago, 5 years ago, 10 years ago, 20 years ago, they start doing things immediately because we want to show the judge this is not who you are. This is a mistake. This is an aberration, and that you are not someone the judge has to worry about because most judges are concerned that if they go easy on a person for a DUI, especially a second DUI, that person is going to cause more DUIs in the future and possibly hurt or worse somebody else. So keep that in mind. Judges are kind of terrified of a second DUI offender because they don't want a situation where they go easy on somebody and something worse happens down the line. We want to show a judge and a prosecutor that we're not that type of people and possibly made a mistake. We're not agreeing to anything. So we want to take things early and do things as soon as possible. We've got a list of things that we will help people do so they put their best foot forward for the prosecutor and judge. And the things we're going to have you do can't be used against you. It can only help you. It's called a remedial measure. And remedial measures in Indiana under the rules of evidence cannot be used to hurt someone that can only help. Keep that in mind, and if we have you do something, it's because we know it will help your case, not hurt your case. Keep that in mind. Second DUI is an uphill battle. Second DUI is a felony. It's a really uphill battle. That's okay, and that's why we're here. We're here to help, and we understand that people are not just their criminal charges. Almost all of our clients are normal, everyday people who got mixed up in some extraordinary type events. I'm not saying my clients aren't amazing human beings, but for the most part, they're not out there causing chaos. Nobody started their day off saying, I can't wait to drive intoxicated. This is going to be great. It happens because lots of things, including alcohol, affects a person's judgment. So keep that in mind. But a second DUI does require massive action. And, a lot of judges are hesitant to allow a person to drive while the case is pending because they're scared of that person continuing to drink and drive, possibly hurt somebody. So in order to keep a person driving, again, there's lots of things we want to do immediately. So we can show up to court and be like, hey, we're not admitting anything, but here's some proof my client is not a bad person, and here's some proof why you should let them continue to drive. Most of my clients need to drive because we don't live in Chicago or New York. There's not L trains and buses going every single direction. There are some buses, but not enough, especially if you live in the suburbs. So getting started early is key to a second DUI defense, and you have to trust me on that. If you are facing a second DUI or a loved one is facing a second DUI, call me. We will talk about DUI defense all day. It's a passion of mine, and I love helping people. Everyone at my firm loves helping people, and we would gladly chat with you and figure out a game plan for you and your case. If you have any questions, give us a call, 317-632-3614, and remember to always plead the fifth.